makes sense that the small claims court is, again, the court of last resort. You try to work it out amicably before you ever get to a court, correct?
Yes,
and then
yes.
you're saying the next step is you file that claim and it may go to a mediator before you get on the docket with the judge?
No, what happens,
or how does that work?
You're already on the docket, you appear in court. When you go to court, the clerk will call the list. While the list is being called, the judge will ask the individuals if they're interested in mediation. If they are, it takes two to mediate. So if they are, then they will assign a mediator who's present that day. And they get them from Roger Williams Law School. I believe some of the colleges send some mediators.
And there's also some volunteer mediators.
Yes, they're all volunteers.
A few programs.
And they would hear the evidence, or they would hear the case outside the courtroom?
Yes.
Just like any other mediation. They take you into a room. They'll sit with you to get the facts. They'll try to perhaps talk to one side, then the other, go back and forth. And in the end, they try to bring you to an agreement. They can't force you to agree. They can't make a binding decision. It's not an arbitration. It's an opportunity to try to get some common ground between the two parties to settle the case.
And if you don't settle, then do you go into that courtroom?
You get assigned a particular judge and you have your hearing. You have a hearing. Now, if they do agree, you ask the court to hear the agreement. It's called a formal matter. You actually write up the agreement on a little form that's called a stipulation, and the courts have these agreements available. So it's designed to be as easy as possible for individuals. And you read that into the record, and the judge will ask the plaintiff, "Is this your agreement?" Yes, and they'll inquire of the defendant the same thing. You want to make sure that it's a voluntary agreement, that they weren't coerced into signing that agreement.
And once the judge signs it, it becomes an order. So the judge wants to make sure that both sides know that this is their agreement. When he turns it into an order, they're bound by it.
And if there is a hearing, assuming there's a hearing because the parties could not agree in mediation, the individual who brought the suit, that being a plaintiff, they need to know that by going to small claims court, you absolutely give up your right to appeal. So you have no recourse. You have no appeal. The defendant does have a right to appeal. If the defendant loses, then the defendant has two business days to file an appeal in district court for a fee.
Right. Now, here's a couple of things in that. When you said it was the court of last resort, it's the court of first resort, but it is also, as Jackie was explaining, the court of last resort, because once the plaintiff files and is chosen to take jurisdiction to small claims court, that's what the rules say, no appeal. If you win, great. The defendant can appeal. If you lose, that's it. Now, the defendant files what's called a counterclaim. We'll use that painting example. Not only didn't I pay that painter who's suing me in small claims court, but they did such a lousy job, I had to hire somebody else to come in and fix it, and it cost me money. I want to get paid. When you bring your counterclaim, you also waive the right to appeal. And it tells you that right in the forms.
Does the counterclaim happen right at the same time that you're doing one?
They send out a long form. It's, I think, 11 and a half by 14. And it's actually a carbon form. Believe it or not, it's carbon.
Still carbon.
And the individual is directed to write their answer on the form. You have 20 days to answer, and you have to send a copy to the plaintiff and send a copy, the original, to the court. On the form that the defendant receives from court are very, very simple instructions on the way they need to fill it out and what their rights are. If the defendant doesn't fill an answer, if they don't complete the answer, it's not filed with the court, then the defendant is defaulted, which means the court is going to enter a judgment against the defendant.
That's when it becomes really interesting, because the next question is, I got a judgment, what do I do now? Because the next step is to try to collect on the judgment. If the person hasn't shown up, you're going to win. It's called a default. The court will default them, judgment will enter for whatever you asked for, but now you've got to collect it. That becomes an interesting process in and of itself.
I should ask, backing up for a moment, if someone wants to go to small claims court, is it possible to get those forms online, or where do they physically go to get those forms?
I don't know that they can get them online right now. It's a very good suggestion. I think they use particular forms. They're carbonized forms.
Right, because they're carbonized.
They would go to district court
and
ask for the small claims clerk.
In Rhode Island, there's small claims court at the 6th Division District Court in Providence in the Garrahy building, and Kent County in 3rd Division, I think that's called, which is Quaker Lane. There's also in Wakefield, whatever division number
Washington
that is.
County.
Washington County.
Yeah.
A small claims court there.
What David means by that is if I live in Narragansett and I have to bring an action against someone that hasn't paid me, because I live in Narragansett, the appropriate venue would be to bring it in Washington County, which is in Wakefield, because Narragansett is in that county. So whichever county you live, that's the county where you want to file your small claims.
Bristol, Barrington, Warren would be, even though it's Bristol County, you would file in Providence.
I guess that also addresses what happens if that person who you want to sue is in Florida. You would still file in the county that you reside?
Now you're talking about jurisdiction, personal jurisdiction.
Ah.
2 kinds of jurisdiction. Subject matter jurisdiction, we talked about that already. That is the court's jurisdiction to hear contract-type claims for up to $2,500. Personal jurisdiction is the court's power to hear a case against a particular person. And it's all based on, basically, where did the transaction happen. It would be, there would be minimal contacts sufficient to bring a case in Rhode Island if the contract that you're suing on was formed in Rhode Island, the work was done in Rhode Island, even though the person who did the work lives in Massachusetts or Florida or wherever. And I think you serve those by certified mail anyway.
Yes, yes.
I know you were alluding to what happens next when it comes to collections, but if we back up for a moment, if you had in good faith been trying to negotiate with the person who owes you money, it's going on for a period of time, but it's not done yet, and you said you've had it, what's the statute of limitations? How long do you, in good faith, negotiate or try to deal with it? Or, on the other side of it, how long do you go before you really are on the short end of the stick for having waited?
I want to say the statute for collections in Rhode Island is 10 years.
Right.
From the judgment. Massachusetts is 20.
From the judgment?
No, 10 years from the date of the contract.
I'm sorry,
From
10
the
years
date.
from the date of the contract.
Okay.
Yeah, and then it's 20 in Massachusetts. You have 20 years to collect your debt.
That's right. And in Rhode Island, it's the same in Massachusetts. The problem is if you wait too long, your evidence is going to get lost, get stale. You're not going to be able to prove your case. So,
Good point.
You're not going to wait a very long period of time. If you called, go back to our painter example, if you called the painter and said, get back in here and fix this or I'm going to get someone else to do it, because I think you do have to give the person opportunity to remedy the situation himself. If he doesn't do that, then you're going to call the other painter and you're going to incur a bill. Now that you have that other painter who did the work, who can come in and testify, this is what I had to do to fix it.
Do I need pictures?
You're going to not only want
Whatever
pictures,
you have.
you're going to want the person who had to come in and fix it and say what was the matter with it, why it wasn't done up to par. If you wait 10 years, you may never find that person again.
Yes.
So it's a problem of letting your evidence get stale. That is more of an issue in small claims than the 10 years statute of limitation.
Point well taken. Now, you were also beginning to talk about what about that collection.
All right.
Please explain that. That's maybe the harder thing.
Yeah, it is.
Address.
You get a judgment against somebody, and they don't pay it. The next step is you have to bring them back into court, and the court has to take a look at what are their assets, what's their earnings. You might want to attach their pay if they earn regular pay, and it's a process in and of itself. It's a new process. The small claims case is done. You get a judgment. The next process, I think, is called supplementary proceedings.
Yeah.
And you've got to drag the person back into the court with a summons and a subpoena.
Who's doing that?
The plaintiff is doing that.
The plaintiff, and at this point, you still say that the plaintiff is able to do that on his own and doesn't require a lawyer?
That's where it gets a little complicated
Right.
because I think they can help you in the clerk's office, but you have to understand they can't give you legal advice.
Right.
But
right.
they may allow the individual to file like a motion to come in to enforce payment.
Okay.
In Massachusetts, as soon as you get a judgment, whether it be by default or by hearing, they issue the judgment, it's mailed out to both parties, and the nice thing is what they do is they automatically assign it to a payment review hearing. So you automatically have to answer to the court.
There's a process already.
Yeah.
Yeah, that's a good idea.
That's a way of doing that.
That makes sense,
Yeah.
certainly. And if, I've heard that people sometimes need to put liens on a property if they've not been,
Right.
now again, for as wise as the consumer could be, is that something that someone could do
At
without
some
a lawyer?
point in time, you're going to want to
You need to
hire
get
a
a lawyer.
collection attorney who
Yeah,
knows how to
collection
do
attorney.
those things. The court will issue you the execution.